welcome to Chicago Media Marketing and Advertising. Joe, how many is this now?
This is number 8 since we morphed into
number 8.
Media
So we skipped December, so it's been 9 months.
Yeah.
It's enough to have a child. So I feel like this is, a very important meeting. I'd like to thank Dahlia for hosting this. Offices are great. I think everybody agrees. Also like to thank our sponsor, Be Found Online, for providing some great food, which, by the way, Dahlia did get. So again, yes, with the help of her beautiful staff of interns. So thanks to everyone there. And with that, we'll start. Dahlia, you good to go?
I'm good to go.
All right.
Before I start, I kind of want to know what you think about what is personal brands. Because when we were doing the research, we defined it in a lot of different ways. Do you have a personal brand, Nick?
I do.
How would you define that personal brand?
Wow, that's really...
It's going to be an interactive seminar.
Huh. Well, a personal brand is really my view of myself as a professional. So when I talk about my brand, I'm really talking about advertising and marketing as it relates to my day-to-day life. Now that intertwines a little bit with the company that I work for. That's kind of weird, but what does that mean? I don't know, legally? Is there some kind of a
Nick,
issue
I'm
there?
so glad you brought that up. You worked hard to develop your personal brand, Nick.
Yeah, I did.
What do you need to know to protect it? And that's kind of why you are all here today. All right, so this is what I'm broadly going to cover. We've got the personal branding versus the intellectual property. Intellectual property is trademarks and copyrights, not really patents for this, but we're talking trademarks, copyrights, things you create. Contracts are a big aspect of personal branding and who owns it. And we're going to talk briefly about employment contracts, what is the work for hire concept, non-compete agreements. Someone hires Nick for his great blog, and then they make him sign all sorts of things. One of those things is a non-compete. How does that impact his ability to move on and call his next thing? What's the effect on side project? Do you have a day job at the night you like to work on your blog? Is that yours? I don't know. How about your, I do know, I'll tell you. And then there's future projects, right? What if I leave that company, what can I work on? And then when we were doing this, we're putting this together, a really good analogy is endorsement contracts. Nick may not be a celebrity in the sense of Star Magazine. I don't know.
He's huge in Japan.
Yeah, he's huge in Japan.
They like me over there.
Right, so celebrities changing with YouTube and with blogs and with Twitter. It's something you can have a huge profile overnight, and people will hire you for that. And it's not dissimilar to an endorsement contract, having a major celebrity endorse your brand or your product. So if you're in that position, how many of you are bloggers? How many of you, and this is the Chicago Media and Marketing Committee, how many of you work for an advertising agency? Okay, and how many of you hold marketing roles? All right. And in that role, what are some of the things you guys are asked to do on a day-to-day basis? I'm not going to, yeah. Man with beer.
I make things look pretty.
What about marketing efforts? What tools have they asked you to use in your effort to brand your business? Twitter.
Facebook, LinkedIn.
Okay, so everyone's using some sort of social media. All right, so let's talk about Jane. Jane creates Jane Brand, and she develops a product with Jane Brand, and she's in charge of controlling the brand's perception. And she starts getting a really loyal following on janeblog.com and on Twitter. Fat Cat Company wants to hire Jane, so now what? Fat Cat sees that she's got a really good following, and they want to hire her for her products and that following. And she's going to be paid a lot of money and thinks it's a great opportunity to reach even more people. So what's wrong? She's basically being bought out. She's super excited, right? Let's ask Sigrid Olsen. If you don't know who she is, she's a painter, she's a designer. She started selling women's clothing in 1999. Liz Claiborne buys the brand, the clothing line, and she keeps a 10% interest, and she remains as creative director. The brand is sold in 50 stores across the nation. Does this look familiar? Maybe, maybe not. Women, maybe? Okay. All right, so this is her goodbye message, because they basically closed down, and she's telling people that she's not selling her clothes anymore. But you can still get to her through this other site. All right, so 2008, Liz Claiborne announces it's closing all of her stores and will stop producing the clothing line. So can Ms. Olsen start her own clothing line now that she's done with Sigrid Olsen? It's her name. Okay. All right, so what happened? Well, basically, Liz Claiborne bought the trademark Sigrid Olsen, and even after shutting the stores down, they still owned it, and they can prevent her from using it. So Nick Kinports, I hire you, I tell you in your contract we're hiring you and your name. Contract, your job ends. Guess what? You cannot be Nick Kinports for the purposes of selling whatever it is you want to sell that the company hired you for. What was the big issue? That was the non-compete contract. And she did go on to selling like paintings and artwork that had nothing to do with clothing, but you can tell that she was very limited for a period of time.
Can I ask a question?
Yes.
Are those non-compete agreements, are they just forever?
They are not forever. In order for a non-compete agreement to be enforceable, they can make you sign something that says you cannot compete ever, or for 10 years, or for anywhere in the world. But most judges will deem that provision unenforceable or reduce it to, at most, 2 years and within a specific geographic location. So if you were only selling in Illinois, and these people never have any prospects of clients in Alaska or even Indiana, then you can make that argument. There's no reason why you should prevent me from working there.
Would Sigrid Olsen have the ability to sell clothing in after 2 years then?
Yes, presumably.
If she wanted to.
Yeah. All right, so let's change the scenario a little bit. We already learned our lesson about your brand. Your brand and your name, even though its name can become a trademark and a company can buy that name. What if they hire you just to tweet for them? You know, she's excited again, big money. What does she need to consider as the personal brand owner, and what does Fat Cat need to consider as the person buying this brand? All right, let's talk intellectual property. So I covered those 3 things. What is intellectual? How many people, hopefully you all do know, what's the difference between a copyright and a trademark? How many of you are like, I know what it is? All right, so if you're in this space, you should know what this stuff is. Because yes?
The trademark applies to a specific name, but a copyright can be more of a general idea of a product.
No, not really. Okay, so it's really easy. Trademarks are brands. Coca-Cola, trademark. Armani, trademark. Going to the store to buy whatever you like because you like the brand, that's a trademark. It's a source identifier. It's why you decide to buy something. It's why you don't buy, or you do buy a Hanes undershirt versus an Armani undershirt, even though they both look exactly the same, right? Copyright refers to everything else that's not a source identifier. So you're talking about this PowerPoint presentation. You're talking about a book. You're talking about the designs and the overall look and feel of your company's website, the content on the website, your photographs, music, video recording. Those are things that are what's called fixed in a tangible medium, and they're things you can read, watch, touch, okay? So when you're working for your company, trademarks are, let's say, Sigrid Olsen's name was selling a brand of clothing, and the copyright would have been the website and the color pattern of that of what she was selling. There's a little overlap in trade dress, which is the look and feel of something can also serve as a source identifier. If you go to a McDonald's somewhere and you don't see any words McDonald's, but you see the red and the yellow, you know you're in a McDonald's, probably, right? That's trade dress, and it can also act as a trademark. So it's good to know those words, because we get calls like that all the time. They're like, I want to patent my logo, and I'm like, can't do that, or I want to patent my book, and patents thrown around a lot, and it's really not right. So now you could say, and oh, those little brochures have the difference too, so you can feel like you're smart and know what that says. Yeah?
What if there isn't a contract? Are these copyrights understood?
If there is no contract, we're going to talk about the work for hire agreement. So this is a really, 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 really important part of this presentation, so everyone should know. In the absence of a contract, if you're an employee for a business, you're on their W-2, you're getting health insurance, you're on a set time slot, without a contract, you don't own anything. Your employer automatically owns whatever you write, whatever you create, whatever you do, and the catch is within the scope of your employment. So if you're hired to be an advertising person, and at home you're creating a dollhouse as your hobby, well, I don't know why I came up with that, but this but the business would not have a claim to the dollhouse.